Vanessa. This is the second day of the part heard case of Vestel Elektronik, the HEVC Advance, court reference A3 2020 0019. Thank you.
Yes, I can see that everybody important is present. Mr. Pickford.
Thank you, my lords, my lady. Yesterday afternoon, I took the court to the key authorities, or at least three of them, on matters relating to, four of them on matters relating to tort, to demonstrate the following principles, and just to recap very briefly. First, that Article 7.2 is to be construed restrictively as an exception to the general rule that you sue in the defendant's domicile. And the reason for that is because the underlying objective of Brussels regulation is to promote legal certainty. Second, that matters relating to tort refers to claims which are based on tort. Third, that there is no jurisdiction under Article 7.2 for any part of a claim which is not based on tort. Fourth, the expression based on a tort means a claim which, one, seeks to establish the liability of a defendant for loss and is not a contract claim. And fifth, the claim itself, of which the court is seized and which founds liability, must be based on a tort. It's insufficient to point to a tort in the background, even an important part of the background, if that is not the claim of which the court is seized. And the final authority I wanted to show the court is that of Foley and Fisher, and that's in the third authorities bundle at tab 30. So if we look at the head note, just read the first couple of sentences for the factual context. An Italian company complained to two Swiss companies that their distribution policy and their refusal to grant patent licenses on the German market in respect of some of their products were contrary to competition law. In response, the Swiss companies applied to a German court for a negative declaration to establish the absence of liability on their part in respect of a potential claim against them for breach of competition law. The application was refused as inadmissible for warrant of international jurisdiction. So the question that was referred to the Court of Justice was whether that was correct, whether there was or there wasn't international jurisdiction. And then if we could go please to Elektronik page 817, which is paragraphs 41 and following of the judgment of the court. And if I could ask the court please to read paragraphs 41 through to 47, which contains the essence of their analysis of the issue.
Yes.
Thank you. And then one sees the conclusion of the court at paragraph 55, and this is repeated in the operative part, but consequently, the answer to the question referred is that Article 5.3 of Regulation number 44/2001 must be interpreted as meaning that an action for a negative declaration seeking to establish the absence of liability in tort, delict or quasi-delict, falls within the scope of that provision. And what is key is that the court needs to be seized with the question of liability in tort. Now, it can be a claim by a claimant asserting liability of a defendant, and it can be a claim by a prospective defendant asserting its own non-liability. But what it can't be is a freestanding declaration alleging neither liability nor non-liability. So, my lords, my lady, those are my submissions on the law relating to matters relating to tort. And then the second requirement of Article 72, I'm going to obviously apply them in due course, but that's setting out the legal framework.
Just before we move on, suppose you had a claim in England, as you can do, where liability for an accident had been admitted and the only issue was damages. Would that be a claim in tort for purposes of 7.2?
We're supposing that one is bringing the claim as a claimant, and the claim and liability has been admitted, but there is a question of damages to be resolved.
Yes, it's a very familiar case. County court road traffic accidents. Insurers sometimes admit liability, but there's a big dispute over quantum, and it goes to court.
Yes,
sometimes liability is admitted before proceedings are issued.
It must mention that I mean, without, I have to say, I haven't given that an enormous amount of consideration prior to now, but I think that would be a claim relating to tort within the meaning of the regulation, because underlying the issue of damage is liability under a tort. But in order to make the claim, you actually have to assert the liability and the damage that follows from it. And obviously the fact that one part of that claim may not be ultimately a live issue before the court, I don't think would change the analysis under the Brussels regulation in that respect.
I think that's my instinct as well. But that means you have to qualify your statement as being, it's not just a case in which liability, the purpose of the action is to establish liability or no. But don't answer it immediately, you want to think about it. But it was just my instinctive reaction to the way I put it.
My lord, that may be right. It certainly doesn't affect anything in this case, because we're not concerned in this case with in my submission, we're not concerned with, I think, the damage that follows.
But I rather suspect Mr. Chacksfield would say that what he is concerned with is seeking to establish the remedies or relief to which you might be entitled were you to bring a claim in tort. And therefore it does fall within Article 7.2. I mean, I'm not going to make submissions for him, but that's what I suspect he might want to say. And it's an illustration which is constant in the law of the danger of taking a statement in a case and erecting it as the rule for all cases. Anyway, there you are. As I say, you don't need to answer it now. But I thought I would give you the question to think about.
Thank you. Well, I will think about it further, and if I may need to return to it after I've had a few moments to think about it in one of the adjournments. But the key point I would make is this, and something that I'm going to come on to, which is that it needs to be the claimant who is relying on its own loss in a positive case, or if it's an assertion of non-liability, the claimant needs to be asserting that the defendant would suffer no loss in an action were it to bring one. And as I will come on to explain, Mr. Chaxfield's case is neither of those. So the second requirement then, under Article 7.2, is that the court seized with the proceedings must be those for the place where the harmful event occurred or may occur. The Court of Justice has interpreted the concept of the harmful event to encompass both the event giving rise to damage and the damage itself. And focusing on damage, the second limb, per Vestel's case, the following principles bear emphasis. First, the Court of Justice has explained that it is only direct and immediate or initial damage that's jurisdictionally relevant for these purposes. And I showed the court yesterday the passage in the speech of Lord Hodge, who summarised the position in AMT Futures at paragraph 15. Second, the damage must entail some kind of tortious liability. It's no good pointing to loss, which does not itself found liability. And I showed the court the passage in Excel at paragraph 67, 3 and 5, where His Honour Judge Waxman noted that the requirement for a liability should be allied to the requirement for a harmful event. And secondly, there must be some event which is caused by some act or omission on the part of the defendant, which causes damage to the claimant, as a result of which the defendant becomes liable to the claimant in respect of that damage. And so my submission, even in relation to a claim for non-infringement, such as in Foley and Fisher, there must be a hypothetical harmful event that arises from the hypothetical tort which the claimant is seeking to disprove. So if I could then come on to apply those principles to this case, we say that ground 3 is unsustainable because the claim that Vestel now wants to bring fails both limbs of Article 7.2 as I've described them. Firstly, it is manifestly not a matter relating to tort for the purposes of Article 7.2, having regard to the principles stated in Calphalis and the authorities that have followed it. We say, far from being based on a tort, it is a claim for a declaration that is not based on a tort, or indeed any other cause of action. It is freestanding. And the court has no jurisdiction over such a claim under Article 7.2. Second, Vestel also cannot identify a harmful event in England or Wales, and for that reason too, Article 7.2 is inapplicable. So dealing with the first of those, the new claim is not a matter relating to tort. There has only ever been one pleaded claim capable of constituting a matter relating to tort for the purposes of Article 7.2 in its proceedings, and that is the now abandoned abuse of dominance claim. A freestanding claim for a declaration about Frand is not one that is inherently based on some form of tortious wrong, nor is it inherently based on a denial of liability for some tortious wrong. There is no claim for a negative declaration in these proceedings regarding validity or infringement. So we are in analogous territory to the action Paulienne in Reichert, where the action against the third party did not depend on there being any wrong committed by that third party. Indeed, I would submit that our case is all the stronger because in Reichert, there was at least a cause of action. Here, there is no cause of action pleaded, and nor is there a denial that we would have a cause of action. And in my submission, that is fatal to any claim for jurisdiction under Article 7.2.
Sorry, Mr. Ticaret, are you making a submission, leave aside jurisdiction, are you making a submission, or is it no part of your case, that the English court, if all the parties were English, couldn't entertain an application for a freestanding declaration of this type? In other words, it's just not something that there's any reasonable cause of action proceeding at all, or are you focusing solely on the jurisdictional aspects?
My lord, this submission goes purely to the jurisdictional aspects. I am not submitting that in an appropriately pleaded case that this court could not grant a declaration without a cause of action. There is a problem, however, with this claim because it is not appropriately pleaded, and I'm going to come on to that.
Yes.
But Mr. Chaxfield has tried to slip himself through a non-existent gap, because the problem he's got basically is he can't make out a case in contract, and he can't make out a case in tort, and so he has to basically have a freestanding claim, and that causes him two problems. One, you can't have freestanding claims in under Article 7.2, and secondly, given the thinness of the claim that he's been forced to plead, because he doesn't want to expose himself to the competition claim, and he doesn't want to expose himself to the contract claim, he doesn't actually have ultimately any basis for explaining how friend is to be determined. But that's my third point on whether this claim is justiciable. That is not the point I'm making here. The point I'm making here is that there is no international jurisdiction under the Brussels regulation.
Whatever it is, it's not a claim in tort, not a claim based in tort. That's an issue.
Within the meaning of the regulation.
Thank you.
And in my submission, it's obvious why that really should be so, because, as I said, Vestel has abandoned the tortious route for the Fram declaration based on abuse of dominance, not part of its claim anymore, and it's evidently decided that the contract route, which is the normal basis for a Fram declaration, doesn't work for it either. And so in my submission, it would be fairly extraordinary if Vestel could avoid the deliberately restrictive, narrow approach to special jurisdiction, which the court has emphasised, for contract claims and for tort claims, by simply recasting its claim, stripping out all the inconvenient bits and just pointing to them in the background. And that's effectively what they're trying to do. That approach would not promote legal certainty based on a narrow construction of Article 7.2. On the contrary, in my submission, it would promote extreme legal confusion and make it entirely unclear where the limits on Article 7.2 in fact lie. And as...
Are you inviting us, Mr. Pickford, to speculate or infer as to why a contractual claim is not brought, or is that just irrelevant?
It's not irrelevant. The court doesn't need to decide it. I mean, I have made the submission on it because I'm trying to explain the essence of the problem that we say Vestel faces.
Yes.
But this court does not need to decide why it is that Vestel has not brought a contractual claim. It simply needs to know that it hasn't done. So, and ultimately, that's the end of it for the court's purposes. As the XL case makes clear, merely having a claim in the background is not good enough. And in Vestel's amended claim, there is no tort or contract claim other than in the background. And in my submission, and this I think to some extent deals with my Lord's earlier question, this claim is not, as I think Vestel is now arguing, one that is in effect for a negative declaration. That was what I understood Mr. Chaxfield appeared essentially to be saying yesterday. Now, in order to even begin to make good such a claim, Vestel would need to plead that it had a defence to a claim for patent infringement. And it doesn't plead any such defence. It does not plead invalidity. It doesn't plead anything equivalent to invalidity, such as obviousness. It doesn't plead non-essentiality. It does not plead it has a license. It doesn't
identify the patents in suit at all.
No. It's not it's not a patent claim. It's not the opposite of a patent claim. I mean, but basically, I take my Lord's point that one needs to be a little bit careful about drawing broad principles from the authorities. But in my submission, one can draw the principle that either you need a claim in the ordinary sense that we think of there being a claim, that's the easy case, or effectively you need the opposite of that, i.e. someone asserting that they are a potential defendant, but there is no liability, there would be no liability here. That's the Foley and Fisher style of case. But our claim that we're concerned with here doesn't have any of those features. So it's not a claim that there is even a contractual or a quasi-contractual right to a license. And of course, if there was such a claim, that would turn it into a contract claim under Article 7.1, and that's not Mr. Chatsfield's case. So what he says now, and indeed only yesterday, is that he would have a claim for abuse of dominance in the future, which he says would act as a defence to a future claim of patent infringement. But he says that he couldn't have pleaded that competition law case now because it hasn't yet crystallised. So that's his excuse for it not being part of his pleaded case. And that submission is misconceived. First point is this. There was absolutely nothing stopping Vestel from having pleaded an abuse of dominance claim in relation to an apprehended abuse. Indeed, it did plead an abuse of dominance claim in relation to an apprehended future abuse. If we go, please, to the RFI response that Mr. Chatsfield took you to yesterday, that's in the supplementary bundle tab 3. And I'm looking at the reply, paragraph 4, first paragraph. It said, it is not the case that the claimants would not seek such declarations. So they're being asked about the circumstances in which they can seek their declarations. In the event that the court were to reject the claimant's case that the second defendant has abused, underscored, its dominant position, the claimant's case in these proceedings is not limited to claims concerning past abuse, but is pursued also on a quia timex basis in relation to threatened future abuses. And see the particulars of claim, for instance, paragraphs 90 and following. And it's instructive to look at paragraph 90. So that's to be found in the core bundle, tab 15. And it's on bundle page 168. So we see there, further, in the event that, in accordance with their threats to do so as referred to above, the defendants or any of them were in fact to seek injunctive or similar relief, such as the recall of products, against the claimants or any of them in respect of the steps, based on the defendant's conduct and licensing offers to date, that would constitute a further abuse of their dominant position. So, my lords, as I understand it, this is at least a version of the type of abuse of dominance claim that Mr. Chatsfield says he couldn't have pleaded, and yet he did plead it, or at least the counsel before him pleaded it. So any problems that Vestel has with pleading a coherent case are nothing to do with the fact that the abuse has not yet crystallised. A second point is that it follows that it would be quite wrong to allow Vestel to rely as part of the explanation of why there is jurisdiction in a case in this case, to rely on a claim which it effectively abandoned a month ago. We have prepared for the last month on the basis of the claim as it has stood. And Vestel cannot perform on 1 hour from closing its submissions yet another volte-face and seek to find some new pathway to establishing this court's jurisdiction. That's simply not acceptable. It's stuck, my lord, with the claim as it's presented it to this court and as it has been presented for at the very least for the last month. Now, third point to make about this new explanation of the underlying abuse of dominance point is, and this perhaps is my problem, but I found it extremely difficult to follow what the claim really is, because previously Vestel based a case of abuse of dominance based on the doctrine of excessive pricing. Now, it was wrong about that, and it was unable to point to any jurisdictionally relevant loss on the basis of that claim. And so rightly, it abandoned it. But a plea of excessive pricing is at least a comprehensible plea in competition law. The new version of the abuse of dominance claim that Mr. Chatsfield was explaining orally seems to be that it would be an abuse of dominance to breach a contract under which Vestel has no rights. And so we seem to be proceeding on the basis that this is not an excessive pricing case anymore, because that's been expressly disavowed. So by assumption, under Article 102, there's no problem with our royalties. They are fair under Article 102, because that's the bit that's been struck out. But nonetheless, Mr. Chatswood is saying that they're non-frand, measured presumably by the standard of some contract, albeit that's a contract under which Vestel has no rights. And the nexus between the breach of contract to which Vestel is not privy, and yet it seems to be pointing, and an abuse of dominance claim, when our rates are by assumption fair ones under Article 102, is wholly unclear. At the very least, it is the sort of claim that one might say would benefit from being pleaded out, if that's really what they're saying, because it's not acceptable to make those kind of claims without them being properly set down so that we can understand them and we can interrogate them. So the fourth point, the fourth difficulty with this this new version of the case is Mr. Chatsfield's exposition of Huawei and ZTE was incomplete. So he took you to the explanation of the case in the Court of Appeals judgment in Unwired Planet, and I'm happy to go back to that. That's to be found in the Authorities Bundle 2 at tab 23. And I would like to go, please, to paragraphs 269 to 270, which are on Elektronik page 626. And if I could ask the court, please, to read to itself paragraphs 269 to 270. So, my lady, Lady Justice Laing, I can't see you. Have you also read the passage? Thank you. So the point being made here is that the requirements, the 3 steps that Mr. Chatsfeld referred to, they are not mandatory steps, and if one fails to comply with them, that automatically leads to go straight to jail. Do not pass go. The point being made is that allegations of abuse of dominance depend on all of the facts, and therefore they need to be properly pleaded. You can't just make them up on the hoof, and you need to identify precisely what it is said that is said to be abusive, and that is not least because they're very serious allegations. I mean, they potentially engage. They are quasi-criminal, but because of the fines that can follow if you're found to have been acting abusively. So the 5th point to make about this new case, and this is really in my submission the critical point, notwithstanding all the other difficulties that Mr. Chatsfeld faces with this new argument, is that even if this allegation of future abuse of dominance formed part of Vestel's pleaded case, it would not offer a defence to a claim for patent infringement. It doesn't make Vestel non-liable for the tort of patent infringement. And it is not, as in the Fujifilm and ADSI case, in substance, a finding of non-liability. Mr. Chatsfeld admitted in response to a question from the court that Vestel is currently infringing, and a determination of, albeit he didn't say which patents because he hasn't pleaded that, but a determination of what is found for a license to patents doesn't change that position. A declaration that our terms were not found doesn't change that position. The most it would be capable of achieving, were it to be pleaded and were it to be good in law, is influencing the relief to which we might be entitled on such a claim if we brought it. And that is not a declaration of non-infringement, either in form or in substance. And then the 6th and final point on this subject is that Vestel gains no support from the Pfizer and Roche case to which it referred. That was a decision following trial, claims for error declarations at which the defendants participated. So no jurisdictional issue arose under Article 7.2, and therefore it's irrelevant, entirely irrelevant to the question of jurisdiction under Article 7.2. So, my lords, my lady, unless the court would like to ask me further questions on that issue, I was then going to turn to the point about harmful event in England.
Can I ask you one question? I think Mr. Chatsfield said that it might provide him with a defence to an injunction, that you might not be able to get an injunction if your terms were not found and you hadn't offered a licence on terms that were found.
Mm-hmm.
Is a declaration in effect that someone is not able to get an injunction sufficiently analogous to a declaration of non-liability?
No, because it isn't an assertion of non-liability, because they would remain liable, and they would remain liable for damages. We could have a declaration that they were liable. That we might not even seek a prohibitory injunction. Irrespective of the particular remedies that might or might not be available, the bottom line position is that it's not a declaration of non-liability, and it's not equivalent to one.
I'm trying to think, I know that this is annoying, throwing questions at you which you haven't anticipated, but I'm trying to think of principles in a different case. Suppose there were a case in which there was an admitted breach of contract, but the real question was whether it was a wholly trivial breach for which the damages would be 40 shillings, or whether it was a really serious breach for which damages would be £10 million. Could the putative defendant start proceedings for a declaration that the damages were limited to 40 shillings, whatever the modern equivalent is? And if so, would that be an action for a declaration of, as it were, non-liability to the higher measure of damages?
In my submission, no, because that is a question about the extent of the remedy, but it is not a question, ultimately, of whether they are or are not liable. And the Foley and Fisher case was quite clear that what was legitimate was for a prospective defendant to come to the court and say, I am not liable for a potential future tort that it's been said that I commit or I might commit. And that is in accordance with the narrow construction that we have to give Article 7.2. The difficulty with the proposition that my Lord has suggested to me is, firstly, it is not a declaration for non-liability. And secondly, were it to be construed as such, that would be so broad, in my submission, as to effectively open up a vast range of potential claims under Article 7.1 and 7.2, entirely contrary to the underlying jurisprudence, which emphasises that ordinarily you sue in the jurisdiction of the defendant. That's the general rule. And there are specific circumstances where you may be permitted to sue elsewhere, but they are to be narrowly and restrictively interpreted to ensure legal certainty. And my Lord's suggested claim, were it permitted, would not be consistent with that.
Okay, thank you.
So turning then to the harmful event. Consistently, we say with the fact that the new claim is not a matter relating to tort, Vestel is unable to identify any harmful event in England which underlies it, or a jurisdictionally relevant one. So Vestel asserts in paragraph 50 of its appeal skeleton, it says the harmful event which has occurred or may occur is, for Advanced Philips, alleged infringement of UK patent rights by sales of unlicensed televisions, and for Vestel, the uncertainty for its UK business due to threats of UK patent infringement and uncertainty of the amounts needed to be paid. So there are a number of points to be made in response to that. The first is this. It's striking that Vestel has adopted both the perspective of the claimant and the defendant as regards loss, and it doesn't seem to know which it really wants to rely on. And that's indicative, in my submission, of it not knowing ultimately which way to turn. Now, as I've explained, the corollary of the fact that there must be a claim of liability or non-liability is that if it's an ordinary claim, the loss must arise as a result of the wrong for which the defendant is liable. First point. And second, it's the claimant's loss that we're concerned with. Conversely, if it is a claim for a declaration of non-liability, first, the absence of loss must arise because of the absence of liability. And second, it is the absence of the defendant's loss that we're concerned with. So if we then apply those principles to Vestel's reference to the loss arising from the alleged infringement of UK patent rights, there are a number of problems with that. Firstly, there is no such allegation in this litigation, as my Lord has adverted to. There is no explanation of which particular patents are being infringed. Vestel does not allege that it has an entitlement to relief that is directly based on its own commission of a tort against Philips. Indeed, it would be somewhat extraordinary, in my submission, to allow a means of establishing jurisdiction to be afforded to a claimant who relies on his own wrongs in a territory to establish, because you don't allow the defendant to commit a wrong in a particular territory, and they say, there you go, there's the wrong. Now I'm going to sue you in the territory where I committed the wrong. That would be a bootstraps argument in my submission par excellence. So Vestel can't rely on harm to Philips because there's no pleaded case of such loss, and it couldn't legitimately rely on its own tort to establish jurisdiction in any event. So let's turn then to the second form of loss, which is the reference to the alleged business uncertainty harm of Vestel. And problems get even worse because first, we are now back in the world of Vestel as the victim, said to be suffering the loss. So, in principle at least, this is a more orthodox approach, but the problem is there is no tortious claim underpinning any alleged harm resulting from business uncertainty. There was, but they abandoned it. Second, there is no evidence before this court to support the allegation that Vestel is at any of there being a harmful event pursuant to which it will suffer harm because of Philips refusing to comply with competitional obligations to notify and offer a license. There is no suggestion in the evidence that we failed to notify our patents before bringing proceedings in Germany. There is no suggestion we are not willing to grant a license. There is no evidence that Philips made threats of UK patent infringement. Indeed, it is not remotely credible that Vestel should actually be worried about being sued in England before a court when it hasn't had, before there being a court somewhere that's had a chance to grapple with Fland. It's obvious from this very litigation that Philips has chosen not to be in England. It has instead sued Vestel in Germany. And it's the German courts that are due to grapple with Fland.
Presumably, if you were to bring a claim for an injunction in England, Vestel would embrace it with open arms because then they could run the question of whether your terms were frowned as an answer to the injunction.
Yes, but we haven't.
And you don't want to?
We haven't. I mean, I'm not able. I'd have to take instructions on the issue of whether we want to. I'm not even sure whether we want to is relevant. Respectfully, the point is we haven't.
You haven't.
Third point is that, and we're dealing here with the loss that Vestel is pointing to based on it being the victim. Third difficulty with this aspect of its claim is that it's conceded in the context of abandoning its abuse of dominance claim that it can't challenge the judge's factual findings on loss from below. It states in terms in its supplemental note that it accepts that it cannot overturn His Honour Judge Hacon's factual findings that the evidence on this application does not establish a loss caused by the need to set aside monies in respect of royalties for the respondent's patent portfolios. That's Vestel's supplemental note, paragraph 2. And that's the allegation that's at the heart of its case on business uncertainty. So that concession is fatal to its case on loss to Vestel. And then fourth and finally, there are a number of further assertions that Mr. Chatsfield has relied upon. Some of them are in paragraph 50 of his skeleton argument. And they all effectively amount to saying there's a potential patent dispute in the background. They're really part of his forum convenience points. He said, well, it's ultimately there are at least some UK patents somewhere here. and that's why you should find jurisdiction. But that is not the test under Article 7.2. As I've explained, that is a hard-edged, restrictive exception to a general rule, and merely pointing to the possible UK patents in the background is nowhere near good enough. So, my lords, my lady, with the court's permission, if there aren't further questions on that issue, I propose to turn to the no serious issue to be tried head, which is my third main point.
Nothing from me.
Thank you.
Yes, Mr. Beckford.
So the third point is this: even if, one, it were procedurally proper to entertain the appeal, that was my first head, and even if there were international jurisdiction, that was my second head, the claim suffers from a fatal defect and would fall to be struck out in any event. And the reason for that is because Vestel asked this court to determine FRAND license terms, but it does not plead any coherent basis by which the court is to do that job. And as such, the claim is non-justiciable. Now, as I've explained, there are two ways in which the English courts have previously been asked to determine matters relating to FRAND in the past. The main way is contract, and I showed you the Unwired Planet case in the Supreme Court at paragraph 58, which explains that point. And the second way, generally somewhat ancillary, is competition law, and that's the way that Vestel used to plead its case. But now, in its pleaded case, it doesn't rely on either of those. Now, what we have seen is a reference to the ITU in paragraph 5 of its particulars of claim. It's a fleeting reference, and it is certainly not a properly pleaded claim for breach of contract, and indeed Vestel accepts that, at least now. And it is not even a properly pleaded claim in respect of the existence of a contract. There is no reference to what ITU rules are being relied on. There is no plea as to when, where, or in what form obligations arose under those ITU rules and between whom. There is no reference to the provisions of the ITU rules under which the obligation is said to arise. There is no reference to how it is that Vestel has any entitlement to rely in this court on those provisions. So despite disclaiming contract, Vestel, or disclaiming a contractual route to an entitlement, Vestel does claim that it can rely on the ITU provisions, as I understand it. As I understand what they're saying from the case yesterday, they say they can rely on the ITU contract by operation of competition law. And as I explained about 15 minutes or so ago, that we don't really understand how that is said to be the case, but perhaps the most important point here, for the purposes of this point, is that's not its pleaded claim. So there is no explanation in this claim as to how Vestel is entitled to rely on the provision that it points to, and there's no explanation of where it is claimed that obligation is to be performed. And these are not trivial pleading points, because to be a meaningful declaration, Vestel must want to have a determination of FRAND in the sense of terms of a license to which it has some sort of entitlement. And you can't do that entirely in the abstract. They don't have a competition law basis for the claim. They don't have a contract law basis for the claim. And the difficulty is that gives the court no guiding lights by which to determine the question of FRAND. If I could just take the example of what is non-discriminatory. If we could please turn to the Unwired Planet case in the Supreme Court That's in Authorities 3, tab 27. And I'm going to be going to the Elektronik page 757 and starting at paragraph 100, or sorry, actually possibly 754. No, I beg your pardon, 756. 756. I'm starting at paragraph 105. So this is the Supreme Court dealing with the question of friend and non-discrimination. Does everyone have the case to hand? Thank you. So 105, Huawei submits that a further error in the judgment of Mr. Justice Birss and in the judgment of the Court of Appeal relates to the non-discrimination limb of Unwired's friend undertaking. This was dealt with under ground 2 in the judgment of the Court of Appeal. Huawei relies on the Samsung license entered into by Unwired as a relevant comparator for the purpose of working out the friend license terms which should have been offered by Huawei to Unwired. The worldwide royalty rate under the Samsung license was much lower, and hence much more favourable to the licensee than the worldwide royalty rate which the judge found was required to be on offer to Huawei pursuant to Unwired's friend undertaking. Huawei submits that the judge should have held that Unwired's friend undertaking meant that Unwired should have offered Huawei a worldwide royalty rate which was as favourable as that agreed with Samsung. So that's the context for the argument. And then we see at 108 that Lord Justice Birss rejected that argument on the facts he found that there were specific economic circumstances applicable in relation to the negotiation of the Samsung license, which meant that the royalty rates in it were not a good comparator or basis for assessment of the uniform market royalty rate required under the friend obligation. And then at 110, we see that the judge accepted Unwired's second argument, and he held that the non-discrimination element in the friend undertaking was general in nature rather than hard-edged. And the court then goes on to explain at 1112 that this court upholds the judgment of Mr. Justice Birss and the Court of Appeal on the second of Unwired's arguments. They were right to find that non-discrimination element in the friend undertaking is general and not hard-edged. 113, the choice between regarding the non-discrimination obligation as general or hard-edged is a matter of interpretation of the friend undertaking in clause 6.1 of the IPR policy. And then one goes on to see the further explanation of they ultimately decide that it's not the hard-edged version. But the key point is that to what non-discriminatory meant in that case, that context of the ETSI IPR policy, all depended on the construction of the ETSI IPR policy, on which the party claiming the entitlement to a license was able to rely. That was under French law. Now, the court notes in paragraph 124 that competition law might, in theory, give a different answer to a question of non-discrimination, because competition law is concerned with addressing anti-competitive effects. And that is not the same necessarily as the construction of what non-discrimination meant under the ETSI IPR policy. And so the point here is that the court can't simply pronounce on what is non-discriminatory in the abstract. First question it needs to ask itself is Vestel owed any kind of non-discriminatory obligation at all? And the second question is, if so, under what laws? And the third question, having determined that, is well, what then is the nature of that obligation? And those questions have to be answered within a legal framework, either contract or tort. They're not capable of being answered at large without guiding lights to steer the court to its answer. And this point is illustrated, the need for justiciability in relation to a declaration, even given that the court's discretion to grant declarations is a very wide one, is made in the case of Office Depot and UBS Asset Management. And this is in the Authorities Bundle 2 at tab 22.
Yes, which paragraph?
So if we begin, please, at paragraph 1, just to explain the context, the matters before this court are contested applications to amend and strike out pleadings. They raise the issue whether and in what circumstances the court should exercise any discretion to grant declaratory relief, determining the performance required to satisfy a party's obligations under a commercial agreement. Someone can see that there are some analogies with the case that we're concerned with. These proceedings concern the design, construction and maintenance of a warehouse. Paragraph 3, the claimant, OD, entered into an agreement for lease with the first defendant, UBS Asset, in respect of the warehouse that was to be constructed. And then paragraph 12 is the essential clause that was in consideration. On the 19th of April 2005, UBS Asset granted a lease of the warehouse to OD for a term of 20 years. The lease contains a tenant's repairing covenant at clause 3.4 to keep the premises in good and substantial repair, maintained and in clean condition. Now, we then see at paragraph 16 and 17, the factual context, effectively, there was a problem with maintenance. The roof had suffered from water ingress and the parties were having a dispute about the tenant's repairing covenant at clause 3.4. And so if one goes to paragraph 36, I'm just getting to 36 myself, having overshot it, we see the claim against the fourth defendant. So the claim against UBS Triton is for a declaration as to what works, if any, OD is obliged to carry out to put the roof into a lease-compliant state. And then at 42, 43, we see the submissions on behalf of UBS Triton, that the claim against UBS Triton should be struck out on the grounds that the amended particulars of claim do not plead a legally sustainable case against UBS Triton. The amended particulars of claim do not plead the facts necessary to enable the court to identify and determine the real issues, in that they identify 4 alternative schemes of work without indicating any preference between them. And 3, there is insufficient detail in the amended particulars of claim as to the nature of the alternative remedial schemes proposed by OD. Mr. Jordan submits that the pleaded case has no real prospect of success. And then beginning at paragraph 50, we see the decision of the judge on the application. The difficulty raised by the pleaded case against UBS Triton is that it does not raise any issue that the court can properly determine. Firstly, there is no dispute between the parties as to the nature and scope of OD's repairing obligations under the lease. OD has an ongoing obligation to keep the premises in repair.
Sorry, which paragraph are you at? 51.
I beg your pardon. So I started at 50 and now I'm on 51.
Yes.
Third line, the obligation is to keep the premises in repair, not by carrying out any specified works, but so as to achieve the specified standard of repair. The choice of works required to maintain the warehouse in the required condition is a matter for OD. It's not open to OD as tenant to require UBS Triton as landlord to identify or agree any particular scheme of works required in order to satisfy OD's repairing covenant. And then the conclusion, paragraph 55, is that the claim for a declaration against UBS Triton is not formulated so that any underlying issue between the parties is sufficiently clearly defined to make it justiciable. And so on that basis, the court rejected the application. And in my submission, however wide the discretion to grant a declaration, it is obviously right that the issue must be capable of proper determination by a court. And I'd like, if I may, to end this point with an analogy, because it's suggested by Mr. Chaxfield that the only thing that's necessary is it forms a useful. There's a useful purpose, and he's picking up on a statement of Lord Justice Birss in the Pfizer case. But in my submission, implicit in that is that the point is justiciable. If the point isn't justiciable, then that is a fatal problem. It can't be that it merely needs to serve a useful purpose. If in fact you couldn't decide the point if you wanted to. So suppose Mr. Chaxfield and Mr. Segan have a real dispute between them. And the issue that's been exercising them for many years now is who between the two of them is the best barrister. Now, let us suppose that resolution of that dispute would serve a useful purpose for everyone, because they're never going to shut up about it until it's resolved. So in order to determine that issue, the court has to have some principles. It needs some criteria against which to judge who is the best barrister. Now, let's suppose that Mr. Chaxfield and Mr. Segan have an agreement that best barrister means the person who has won the most round cases in the course of their career. And suppose Mr. Chaxfield prays in aid that agreement, then perhaps if that is binding parties, they perhaps could decide the dispute by reference to that agreement. But in the absence of legal framework, the question is simply not capable of being properly determined. One asks the question, best in what sense? And in my submission, the court similarly needs a framework for resolution of what is friend. And irrespective of whether it could plead one, Vestel's pleaded case does not offer one. And that's the key point. And as we infer there's a reason for that, because they know that whichever way they turn to try and plead one out fully, they get met with us saying, aha, well, you've got a tort claim, and they've abandoned the tort claim. Sorry, you've got a tort claim based on abuse of dominance, and they abandon that. Or we say, aha, well, your claim is in fact a claim for contract. And that way they find blocked as well. So if I'm right that Vestel's claim as pleaded is deficient in these respects, this court should not allow the amendments to add matter because the resulting claim has no real prospect of success. And if that's right, the entire claim falls to be struck out, because having removed the abuse of dominance claim, but then failed in its attempt to add matter in the form of the standalone claim for declarations, there'll be nothing left in the claim against us at all. And if there's no claim, there's nothing over which to declare that the court has jurisdiction and the appeal should be dismissed. So, my lords, my lady, those are my submissions on my three heads for opposing the appeal. My lord raised a question yesterday about the application of the withdrawal. Whether that was also something that you'd like me to address the court on, but I'm happy to do so if it is.
Well, I don't really mind whether any of you address it. I just put it out there as something which we might need to think about it. And if you want to say anything about it, you could say something about it. If you don't want to say anything about it, I can't force you to.
Well, let me then say this. So I will say something relatively short about it. There appear to be two questions broadly which arise under the withdrawal agreement. Firstly, does the Brussels regulation apply as of now to this claim? Were the amendments permitted? And secondly, would it apply to a fresh claim if a fresh claim was now brought? Now, the first question is answerable in my submission in a straightforward manner, pursuant to the withdrawal agreement itself. I'm afraid we don't have the provisions in the bundle, so I'm going to have to make some submissions to the court. But hopefully they should still be relatively easy to follow. So the first point is that the civil jurisdiction and judgment amendment EU exit regulations. So these are the UK regulations which implement the agreement. But by Regulation 89 of those, with effect from the 31st of December 2020, the Brussels I recast regulation was.
Yes.
However, there is a saving under Regulation 93A to give effect to what is Article 67 of the withdrawal agreement. What Article 67 provides relevantly is as follows. Subparagraph 1 provides that in the United Kingdom, as well as in member states in situations involving the United Kingdom, in respect of legal proceedings instituted before the end of the transition period, and in respect of proceedings or actions that are related to such legal proceedings, pursuant to Articles 29, 30, and 31 of the regulation. A, the provisions regarding jurisdiction under the Brussels recast regulation shall apply. The grammar is, in fact, the provisions shall apply, and then A is provisions regarding jurisdiction and regulation. Now, Vestel has never suggested to us that this claim is not one that involves legal proceedings instituted before the end of the transition period. And we haven't taken a position, we haven't taken a point on that. We have been willing to proceed on the basis that the Brussels regulation does apply to the whole of the proceedings as Vestel contends against us. Now, if that is wrong, I mean, we said that is in fact right because the legal proceedings were instituted before the end of the transition period. But if that's wrong, that would be another reason to dismiss the claim, because it will be quite unfair and inappropriate for Vestel to be able to abandon the case that it's made against us, that we have to consider these matters under the Brussels regulation, and say on day 2 of the appeal, actually, it's not Brussels regulation, it's PD6B. I haven't prepared on that basis. I've prepared on the basis that they say that it's Brussels regulation. So that's the first point. Second point concerns if the question of whether Vestel were to issue a new claim form now, and would Vestel's new claim be one that was adjudicated under the Brussels regulation? It's clear it would not be legal proceedings instituted before the end of the transition period. Obviously, it's instituted after the transition period. So the question that would then arise is whether the second limb of Article 67(1) was engaged, namely that the proceedings were, sorry, I'll just go back to the words, make sure I get the words correct. The proceedings are related to legal proceedings instituted before the end of the transition period, pursuant to Articles 29, 30, and 31. Now, in my submission, they would be related proceedings, because, of course, we have proceedings, for example, that are afoot in the Netherlands. And Articles 29 to 31 are dealing with the lease pendants provisions under Brussels regulation. And therein they contain a definition of what related proceedings are. And those proceedings in the Netherlands were instituted before the end of the transition period. And in my submission were new proceedings to be brought in this jurisdiction. It is likely, at least, that there will be related proceedings. One would have to obviously analyse exactly what the nature of the claim was. But if they were the same ones as currently being suggested, but brought again, in my submission, they would be likely to be related proceedings. But we don't get there, I say, for the reason that it's never been suggested by Vestel that these are anything other than legal proceedings instituted before the end of the transition period. And so we're under the first limb, and we've been happy to meet Vestel's case on that basis, and I've explained to you why, under the Brussels regulation, there is no jurisdiction.
Thank you, that's very helpful. Would you be able to, at some stage, send us copies of the exit regulations and the withdrawal agreement?
Of course, and I apologise to the court for not having managed to achieve that before this month, but we will do so, of course.
Thank you. Does that conclude your submissions?
My Lord, I think it does. May I just take a very brief opportunity to check with those instructing me and those in the rest of my team that there's nothing else that they want me to say before I formally hand over. I saw a message from my team, hopefully not saying you missed the critical point. Yes, it was simply it was those instructing me would like to make it clear, in case it wasn't already obvious, that the discussion that we've just had, the hypothetical discussion about a new claim, is obviously without prejudice to any points that we would make about such a new claim being abuse of process. I don't want it to be understood that the fact that I've countenanced a hypothetical claim means that I accept that it would be legitimate to bring. And then on my Lord's question that I was going to come back to my Lord on, may I have a few minutes after the short to come back very briefly on that?
Well, I think if you're going to metaphorically sit down now, we'll take a break in any event, and I'll let you say what you want to say after 10 minutes. Just before we take a break, I'll ask the other members of the court if you have any questions for you. Lady Justice Laing, Justice Birss. No. Well, we'll take a break then now. I'll make it 11:44. We'll resume at 11:54, and you can say anything you want to say then.
Thank you.
Thank you very much.
my lord, it's possible that you said something, but you were on mute, I believe.
Yes. Yes, Mr. Pickford, I think we're all ready.
Thank you, my lord. So I'm glad to say that having been given the opportunity to think about it a little more, I stick with my original answer, but I'd like to explain it just a little bit more fully.
Yes, yes.
So the question that was posed was in this hypothetical road traffic accident where liability isn't contested, could the claimant, as I understand it, could the claimant bring its case under the Brussels regulation, assuming that the other the facts sufficiently made that out? And in my submission, it could, and the reason for that is notwithstanding that the question of liability might, in that particular case, be conceded. Loss in that case, which is the question that the court would need to determine, is inherently allied to a question of liability. If one imagines what the pleading would look like, it wouldn't just start by asserting something about loss in the abstract, or about the damage that someone might be caused in the abstract. Say, this person did these things, they were liable for them, they admit liability, and therefore the question that the court has to grapple with is damage. But inherently, even though it's been conceded, the loss and the liability are allied to one another, and that relates to the point that I showed the court and the jurisprudence that talks about the necessity for liability and loss to be allied with one another. What that doesn't entitle someone to do is to rely on their own wrong, to choose jurisdiction by wronging someone in a particular place, and then saying, well, on the basis that I wronged you here, I'm now going to have jurisdiction here. What the potential hypothetical defendant in a case for a declaration of non-liability can do is say, it's been suggested that I might have done something that was going to harm you, or has harmed you, or will harm you. I'd like it to be made very clear that I haven't, that there is no liability. And that is something that they're entitled to do. That's the Fujifilm case. But what they're not allowed to do is come to the court and say, well, I'm now going to rely on my own harm that I did to you, to now force you to engage in proceedings with me in the court that I've chosen, rather than your domicile. That's one thing it can't do. And also, what it can't do is what Mr. Chaxfield seeks to do, is additionally, also has the problem, he doesn't even have a pleading about tortious harm for patent infringement. Yeah, he hasn't pleaded the patents that he's infringed. There's none of that there. This is as I've explained to the court, a claim which is freestanding. He simply says, "Give me a Tran declaration. That will be helpful," and that's not, in my submission, good enough. And this also comes back to the point that I have emphasised to this court, that if I'm wrong, and in fact you are allowed to adopt the broad interpretation of Article 7.2 that Mr. Chaxfield does, then it's very hard to see where the limits ultimately are in relation to that provision, and that cannot be consistent with the jurisprudence, which says actually it needs to be restrictively interpreted. And then the final point is that, in particular, this is perhaps a slight red herring, but no, it's in relation to insurance cases, which is one of the things that was potentially concerning my lord. Of course, there are other provisions that might well apply. So, for instance, it might be a contractual claim, in which case the contractual provisions apply. There are other provisions from Article 10 onwards that deal specifically with insurance contracts. So insurance particularly, and the difficulties to which those sorts of situations arise are dealt with elsewhere.
I don't think a road traffic accident claim for personal injuries is an insurance claim for the purpose of the convention. Even though the insurers fund it, it's a personal injuries claim. But yes, I have your submission. Thank you. I think it follows from that if you had a road traffic accident, which had taken place in England, so there was no doubt whether a harmful event occurred, and there was a dispute whether the damages were fairly minor or life-changing, and which affected quantum but not liability, you accept the claimant could initiate proceedings in the UK against a foreign-based defendant on the basis the harmful event occurred in England and it was a claim based in tort.
Yes.
But the defendant could not initiate proceedings in your submission against a foreign-based claimant raising the same issue, whether the injuries which the defendant had admitted being liable for were minor or life-threatening, because then the defendant would be seeking to rely on its own wrong in England to found jurisdiction in England. Is that right?
That's correct. That's my submission in relation to my Lord's point. But of course, but additionally, there is. I think it's important not to lose sight of the fact that there is an additional problem that Mr. Chatfield faces, because his case is not analogous.
I have all that.
To my Lord's.
Yes, I have your submission. One string to your bow. But on this question of whether you can bring within Article 7.2 something which doesn't actually raise liability, but raises the relief to which a tort might give rise, we now have your submission.
You do.
That's enough for me. I don't know if either of my colleagues want to raise anything like that. No. Thank you very much, Mr. Pickford.
I'm grateful, Lord.
I think, Mr. Segan, it's you now.
Yes. Can I start by making sure that I can be heard properly? Thank you. My lords, my lady, I was going to make my submissions under 4 main headings. Firstly, the factual background as regards my client, Advance. Secondly, the proper characterisation of Vestel's claim. Thirdly, permission to amend. And then fourthly, the 3 stages of the jurisdictional analysis at common law. So taking the first of those topics, first the factual background. Advance is, as you know, a company incorporated in the United States of America, in the state of Delaware. It has its headquarters in Boston, Massachusetts. Advance is the licensing administrator for the HEVC patent pool. Advance does not own any standard essential patents. Advance has not therefore given any FRAND undertakings to any relevant standard setting organisations, nor therefore could it bring any infringement proceedings. Advance has been constituted for the specific purpose of offering the PPL on behalf of the members of the pool. And there's no dispute that Advance has no authority to enter into a license agreement on materially different terms. That's Ayrton 4, paragraph 6. Now, the pool now has over 30 licensors in it. The members are listed on the Advance website. They include, this was in evidence in Moss, paragraph 14, they include some very large and well-known companies, such as General Electric, Dolby, Warner Brothers, Samsung, Etri, and of course, Philips. Less than 2.5% of the patents in the pool were UK patents as at the date of the evidence for the hearing before His Honour Judge Hacon. That's Ayrton 2, paragraph 9. The largest proportion consists instead of US patents. Now, the purpose of creating this pool, naturally, is to enable implementers such as Vestel to obtain from one source a pool license for as large a proportion of the relevant SEPs as is possible. Implementers such as Vestel nevertheless remain, of course, entirely free to approach and seek licenses on a bilateral basis from individual SEP holders. And as the court may know, that's largely what happens in the context of the 2G, 3G and 4G mobile telephony standards that were the subject of the Unwired Planet and Conversant case, where patent pools are not so common. But in practice, the industries using the relevant video compression technology have recognized the value of being able to take a pool license from Advance. At the time of the first round evidence, the number of licensees under the PPL was already 95. That's Ayrton 1, paragraph 4. In the time since then, it has more than doubled. And as I explained in paragraph 13 of my skeleton argument, it's now 195. Those licensees include, on Vestel's own evidence, this is Gelogden 1, paragraph 8, Vestel's two largest competitors in the European market, who are Samsung and LG. Now, Mr. Chatfield spent a considerable amount of time yesterday making submissions which he introduced under the heading Facts. Now, regrettably, those submissions were, we say, not at all balanced, and we simply don't accept the slant which my learned friend has sought to put upon events. I shan't go through point by point, because ultimately none of this is relevant to the jurisdictional analysis, but it's important that I pick up some of the more salient points that he made. Mr. Chatfield began with reference to my client's letters of April and October 2017 to customers. He said that these were threats, and he sought to imply that my client had been behaving somehow unreasonably by sending them. What he didn't do is take you to. They are in the supplemental bundle, tab 12. Sorry, the transcript, as I said, April, I think, and October. There's August and October. So page 71, tab 12. Obviously, there are redactions. These are letters to suppliers following up on sale of unlicensed HEVC products. So that's the second line. There's then an introduction to the pool in the second paragraph. Third line, we explain that X is selling unlicensed products that use technology essential to HEVC and therefore infringe, etc. And then the punchline over the page 72, is rather than referring this matter to our litigation counsel, fourth line of the paragraph after the table, I'm writing to ask your assistance with only the suppliers listed in the table above. And then they ask for contact details of someone at the supplier. Now, in my submission, that's an entirely reasonable letter to write to a distributor dealing in unlicensed goods, asking for contact details from the supplier. Absolutely reasonable. And the same thing can be said, in fact, about the Eisenfurch-Pfizer letter, which is one tab back in tab 11, which my learned friend took you to. This is a letter, supplemental bundle tab 11, from German lawyers. And it records, second paragraph, that Vestel received numerous detailed claim charts in early January 2017. So that's a year and 4 months prior to this letter, Since then, Vestel has not responded to the substance of these claim charts, and HEVC advances it's left entirely in the dark as regards Vestel's position. And then they mention unreasonable delay, Huawei and ZTE, and the possibility of an injunction. Over the page, we look forward to hearing from you promptly. Again, in circumstances where, for a year and 4 months, there had been no response to claim charts, an entirely reasonable letter to write. And I note here that that's a letter from German litigation lawyers, which of course is something that we'll come back to in the context of Forum and the German litigation. Now, it's common ground that there were then meetings in June and November 2018, but still Vestel had not made a counteroffer. So here we were, a year and a half down the line and more, all the while Vestel infringing, and still it has not made any counteroffer of what it said was frowned. Mr. Chatsfield said to you that Advance had not justified its rates, but as he must surely know, there is an extremely detailed and careful document described as a white paper, which was indeed in the bundles for the High Court, which goes into great detail, explaining exactly why the rates and the terms of the PPL are frowned. It's not before this court because Mr. Chatsfield gave no notice at all that he was going to take any of these points. So Vestel didn't make any counteroffer at all before then suing in the UK. We say that the conduct of Advance and the pool licensors in all of this has been entirely reasonable, and that it's Vestel that has been behaving unreasonably by failing to make any counteroffer and then suing in the UK. And my learned friend then turned to his client's substantive arguments on frown. And he sought to rely on a comparison with the MPEG-LA rate and the overlap in patent coverage between the pools. Indeed, he described that as the crux of the dispute. But what he failed to mention to you is that there is actually a duplicate royalty policy and a duplicate royalty implementation process which deal with this precise issue and provide for refunds by the relevant licensors. That is a way of dealing with the issue which is accepted by the very numerous licensees of the advanced pool. There are, I am instructed, 87 common licensees who have licenses from both pools.
Are you able to explain to us, Mr. Singh, I don't think it matters for today's purposes, but just as a matter of interest, why you have what on the face of it seems an arrangement where certain patents appear in more than one pool?
It's an artifact. This has gone into in the white paper, but it's an artifact of the way in which my client's pool came to be created in the first place. In other words, what it comes to is this: in the initial discussions about the formation of a pool, a group of licensors became concerned that the rate that was being proposed on behalf of MPEG-LA was in fact unduly low, precisely because the members of that pool were predominantly implementers who stood to benefit more than they stood to lose from the rate, and other licensors chose to come into the advanced pool, and the dealing with the overlap has been a matter of, it's been a sort of incremental process. In fact, there are, as I understand it, licensors who have switched pools, and that is or who became members of both pools, and that's where this issue of the duplicate royalty comes from. But as I say, it's actually dealt with by a specific policy. It's all set out in the white paper that was actually in the High Court bundles before His Honour Judge Hacon. It's not in this bundle because it wasn't an issue for this appeal. But even if there were no duplicate royalty policy at all, as my Lord Justice Nugee observed yesterday, there is no obligation on an implementer to take both pool licenses anyway. An implementer could instead take a pool license from one pool and seek bilateral licenses from the other licensees. As it happens, the figure that you were given for the overlap is now out of date. The size of the HEVC advanced pool is increasing all the time, both in terms of licensors and patents in the pool. It's grown significantly, but the rates have stayed the same. And it's been confirmed to me I am right when I said that there are licensors who switched to advance. Now, as I'll be showing the court in due course, the precise issue of the comparison with the MPEG LA rate was looked at in great detail by the Düsseldorf District Court in the mass electronic case, and the PPL was determined to be franked. And I'll come back to that and I'll show you. As I say, these are not issues for the appeal, but it's important that I place on record that we say that what Mr. Chatsfield said is highly contentious, we don't accept it, and you don't have the materials in the bundle to resolve these issues to be resolved. And that's what I wanted to say about the background. That brings me to the second topic, which is the proper characterization of the claim. As we know, Vestel's claim, when issued, alleged that my client had committed, or more accurately, was likely to commit at some point in the future, the statutory tort of abuse of a dominant position. This was a competition law complaint. It was made under Article 102 TFEU in Section 18 of the Competition Act 1998. There was no pleading under the tort of patent infringement. There was no pleading of any kind of contractual claim or contractual rights or anything of that nature. There have been a series of twists and turns in Vestel's case. I have summarised them up to the point of this hearing in paragraph 2 of my skeleton, which I don't repeat orally, but I rely on as a summary. The critical development in recent weeks is, of course, that referred to in paragraph 2.5 of my skeleton. As we know, Vestel, a month ago, abandoned its entire competition law case. The court saw yesterday the red line version of the pleading. All the pleas about alleged dominance, irrelevant markets, and abuse have been deleted. As Mr. Pickford has already observed, the problem is that having removed the legal underpinnings of the claim in that way, the amendments left no pleaded legal touchstone against which to embark upon the Frand analysis required by its declarations at all. And a good example of this is a paragraph that Mr. Chatsfield asked you yesterday to pause and focus on, particularly. It's in the particulars of claim, paragraph 51, that's at core tab 15, page 159. And it was submitted that it was particularly important to focus on this paragraph. Paragraph 51, page 158 to 159, which alleges that HEVC Advance has unjustifiably been threatening Vestel with injunction proceedings. The aforesaid threat, coupled with the demand for license terms which are unframmed, constitutes a form of or attempt at illegitimate hold-up. Now, for so long as this was an Article 102 claim, subject to all the other problems that that claim had, that paragraph at least made sense. But if competition law has gone and there is no contractual claim, then what is this paragraph supposed to be alleging, I ask? There is no tort of holdout. The court is given, or hold up, the court is given no legal standard, as Mr. Pickford has already observed, according to which it is supposed to judge the allegation in that paragraph. Now, when this point about the lack of a legal standard was taken up by the court with Mr. Chatsfield, his answer was a further development, or to be frank, U-turn. This one in a sense, even stranger than the previous ones, because whereas as I understood it, where we got to was that Vestel wants the court to make declarations as to whether the PPL is frowned by reference to the contractual standard in the ITU declaration, but without actually pleading or invoking that contract, not for the purpose of any anticipated contractual defence, but solely for the purpose of informing an unheralded future competition law defence under Huawei and ZTE. And when asked what standard the court should apply to Judge Frand, Mr. Chatsfield said, the Frand undertaking given to the ITU, but irrespective of a contractual right. That's page 59, lines 8 to 16, and he added that the Frand licence then is that which is defined insofar as it is defined or arises out of the ITU rules. So that's not a contractual claim, that's an abuse of dominance claim. That is not an argument you will find suggested anywhere, most importantly in the pleading, but nor does it feature in any of the documents for this appeal. It's so new that no one had even included Huawei and ZTE in the bundles, and so my learned friend was forced to introduce the case to you by showing you parts of Unwired Planet that talked about it. Now, there are two possibilities here in my submission, neither of which avail Vestel. The first possibility is that my learned friend is effectively trying to revive the competition law case that was only a month ago abandoned. And we should be absolutely clear about this. As you saw from the red line sections, and as Mr. Pickford has shown you earlier today, my learned friend's case previously pleaded that the PPL was not frowned under competition law standards, i.e. the exact thing that Mr. Chatfield at some point appeared to be reviving yesterday. But of course, jurisdiction over such a claim was rejected by the High Court and then hasn't been pursued on appeal given the findings on loss and damage. Now, to make out of Huawei and ZTE defence, of course, the implementer needs to plead dominance, abuse, etc. But my own friend did have pleas about those things, but they've all been deleted. There is no pleaded case asking the English court preemptively to resolve a competition law case at all. And what is more, as Mr. Pickford pointed out, the whole essence of the Court of Appeal and the Supreme Court's analysis of Huawei and ZTE is that it's a safe harbour and that non-compliance with the contractual undertaking is not the same thing as abuse of dominance. So that first possibility as to what is going on here is simply doesn't avail Vestel at all, even if it were open to them. The second possibility is that my learned friend is trying, via the rather elaborate vehicle of a putative Huawei and ZTE defence, to introduce a contractual claim into these proceedings in substance, whilst simultaneously disavowing it as a matter of legal form, a contract-like case, as it were. But that is, again, in my submission, simply not open to Vestel on its pleaded case. As Mr. Pickford points out, there is no pleaded contractual standard at all. If Vestel had pleaded such a claim, then all sorts of things would have needed to be pleaded and would have arisen. Mr. Pickford has given you a list of them, and I respectfully adopt it. I can add some further issues. The ISO ITU undertaking, by contrast with the HEVC undertaking, has no governing law provision. Vestel would have had to specify what the governing law was actually said to be, and Vestel would then have had to plead on what basis it was entitled under that body of law to enforce the undertaking as a third-party beneficiary. As we know, the HEVC FRAND obligation is enforceable by third parties because of the French law doctrine of stipulation pour autrui. And there's a whole section of my Lord Justice Birss's decision in the Unwired Planet case dealing with the French law evidence on this and coming to a conclusion on it. Vestel has pleaded no equivalent analysis in relation to the ITU or the ISO at all. What is more, it would have had to have explained how, on what conceivable basis my client could be brought into the contractual analysis when it owns no patents and has not given any FRAND undertakings at all. But of course, it hasn't done any of those things. And as I observed in paragraph 2 of my skeleton argument, the Supreme Court has repeatedly reiterated the importance of keeping the analytical focus in jurisdictional matters upon the pleaded case. And if one looks at the pleading as it now stands, there just isn't any relevant category of pleaded legal obligation. Now, that's what I wanted to say about the proper characterisation of the claim as I now understand it. The third topic I wanted to deal with was permission to amend. And it's worth just showing you very briefly an authority on this. It's called Quanta. It's in Authorities Volume 2, tab 16. This was, I don't think it matters, but just to introduce it, this was a claim by a Kazakh bank alleging conspiracy by 15 defendants, including its former chairman, to defraud the bank of more than $1 billion. And an issue arose in relation to amendments sought in the context of a jurisdiction issue. And at paragraph 47, Lord Justice Tomlinson, for the Court of Appeal, and I can pick it up in between letters C and D on page 842 of the report. It is, however, trite that permission to serve outside the jurisdiction only extends to those causes of action which the applicant for permission has identified in its application as satisfying the relevant criteria prescribed under CPR 637. This principle is unaffected by the Supreme Court having indicated in NML that the rule in Parker and Schuller should no longer be followed. It is one thing to set up another distinct cause of action which was not before the judge upon the original application, which may now be allowed. However, in order to do so, the applicant needs the indulgence of the court. The permission to serve out of the jurisdiction is limited to the causes of action for which it was sought unless and until extended. There's then a discussion of precisely what suffices, and if I can take you over to paragraph 49 on page 844. Lord Justice Tomlinson refers to 6.37, and in the fifth line he says, the notes to CPR 6.37 give guidance as to how the evidence may be given. I do not rule out that it may sometimes be convenient and appropriate for matters such as the identification of the ground upon which reliance is placed to be clarified or supplemented in the skeleton argument placed before the judge on the ex parte application, but it is not best practice. The formal material ought ideally to be found in one place, which can always be amended if initially defective. And then this, it goes without saying that the identification of causes of action and their corresponding gateways should be explicit. Identification by implication is not enough. Now, that makes clear that the permit, as Lord Justice Tomlinson said, the permission is limited to the causes of action for which permission was sought and obtained. Insofar as one wants to extend that, the indulgence of the court is required, and it's not enough to say that some cause of action or gateway was impliedly put in issue by a pleading. It has to be explicit, and it ought to be in the pleading.
I don't think it says it has to be in the pleading.
No, it has to be in one place.
It can be in your application notice. You start an application for permission to surveyed by an ex parte application, usually to the master, in which you say, I want permission to survey it under the following gateways.
Yes, your Lordship's right. In relation, I should have been more precise. In relation to the gateways, they are likely to be specified in the supporting evidence. In relation to the cause of action, that's what needs to be in the pleading. At any rate, we are a long, long way away from that paradigm case here, because where we have got to is that Vestel is asking the English courts to assume jurisdiction over a US company to consider its paragraph 93A declaration according to a contractual standard that doesn't feature anywhere in the pleadings or the evidence, in the hope of resolving a putative competition law defence, which again is not pleaded, but more personally hadn't even been mentioned until oral submissions yesterday. And that is a request made on the basis of a case which everybody agrees, wasn't advanced before the High Court. A strikingly unfair manner of proceeding. We agree with Phillips that the court should refuse permission for it. I adopt everything that Mr. Pickford has said. In that regard, I've explained in our skeleton argument why we say that Vestel should be refused permission to amend to bring the case it wishes to bring. Mr. Chatsfield said repeatedly yesterday that the paragraph 93 amendments were not formally opposed, and he was borrowing that language with slight adaptation from paragraph 115 of His Honour Judge Hacon's judgment. But what Vestel's position fails to recognise in my submission is the highly material change in circumstances since His Honour Judge Hacon considered the matter. At the time, of course, Vestel had not abandoned its entire competition law case and therefore the underpinnings for the claim it was bringing. The effect of the abandonment of the rest of the case is to transform the context in which paragraph 93A now arises. Deleting words can sometimes have a dramatic effect on what remains. And in the changed circumstances, we oppose permission to amend not merely as we did below, on the basis that the amendments make no difference to the analysis, but also because, for all the reasons Mr. Pickford has already addressed you on, the effect of adding 93A is now intended to be to add a completely different claim to the proceedings of wholly uncertain ambit, and that is simply unfair. And the indulgence of the court should not be granted, to use the expression that Lord Justice Tomlinson used in the Aquanta case. That's permission to amend. I then move to the fourth of my topics, which is the three stages of the jurisdictional analysis. The starting point, of course, is that as a company incorporated in the USA, permission for service on advance outside the jurisdiction is required under CPR 6.36. The general principles in that regard were helpfully summarised in the judgment below, core bundle, tab 9, paragraph 75, there is reference to 6.37. There's then reference in paragraph 76 to the three-stage test as summarised in Brownlee. And I shan't take you through them all, but the learned judge in paragraph 77 to 87 dealt with the jurisprudence in relation to each of the three stages of the test. As I understand it, there's no challenge from Mr. Chatsfield to the correctness of that summary, and I respectfully adopt it. The three requirements, therefore, are firstly a good arguable case under one or more of the gateways. Secondly, a reasonable prospect of success in the claim. And thirdly, that England and Wales is the proper place to bring the claim. And it's important to emphasise for present purposes that the burden lies upon Vestel at all three stages of that analysis. It must establish each of those three things to the requisite standard. As you will have seen, the judge dismissed Vestel's case at the first stage and therefore dealt only obiter with the second and didn't deal with the third. But to obtain permission for service outside the jurisdiction upon advance, Vestel would need to satisfy you that all three conditions were satisfied. In my submission, the latest reformulation of its case satisfies none of the three requirements. Let me take them in turn. Firstly, good arguable case under the gateways. I'm going to take the tort gateway first. So that's gateway 9. This is the topic raised by the third round of appeal, the new point which has been discussed this morning. The tort gateway is set out, we can find it in the authorities bundle, volume 1, tab 3. I know it will be very familiar, but it's worth just locating ourselves in it to start with. So, authorities, volume 1, tab 3, second page. It's not, they're not numbered, but it's the second page. And it's headed Claims in Tort. Just under halfway down the page. A claim is made in tort where A, damage was sustained or will be sustained within the jurisdiction, or B, damage which has been or will be sustained results from that committed or likely to be committed within the jurisdiction. That's what that is the actual rule that we are applying here. As the claim was formulated before the High Court, a claim was indeed made in tort. It was for the statutory tort of abuse of dominance. The problem was that Vestel failed to show a good arguable case that it was going to suffer any damage within the jurisdiction. But as we know, that claim is no longer pursued and no other tort claim is made in its place. So just reading and applying this gateway on its face, it is quite plainly not satisfied. No claim is made in tort at all. Now, in an attempt to get around that, Vestel seeks by ground 3 to contend that it can satisfy the tort gateway on the basis, as it puts it in its skeleton argument at paragraphs 49 to 50, the claim relates to potential liability in the UK in the tort of patent infringement. And the point rests ultimately on an analogy with cases about declarations of non-infringement. In particular, the Fujifilm case about arrow declarations. Now, in our submission, the point simply doesn't work, and one needs to look at Fujifilm to see why that is so. So we find Fujifilm in volume 2 of the authorities bundle at tab 18. This was to introduce the case, a claim against two companies in the AbbVie group, one a UK company and one a Bermuda company, for an arrow declaration in respect of a UK patent. Amongst other applications, AbbVie Bermuda challenged the grant of permission to serve outside the jurisdiction. The court, Mr. Justice Arnold, as he then was, at paragraphs 15 to 17, gave a brief summary. So this is page 257 of the report. Gave a brief summary of the nature of arrow declarations. And the point I would highlight is that in paragraph 17, second line, an arrow declaration enables the court preemptively to determine a patent infringement case before the patent has even been granted, without having to decide whether the patent would be invalid or not infringed, because the claimant's product will not fall within the claims when granted. It's worth then noting that, in fact, the ratio of this decision, which is paragraph 69 to 80, was that Article 24 of Brussels Recast gave the UK courts exclusive jurisdiction over such a claim because it was a claim in respect of a UK patent. So that's the reasoning for which this is actually authority, paragraph 69 to 80. And you can see in 80, Mr. Justice Arnold says, for the reasons given above, I conclude that the UK courts have exclusive jurisdiction over FKB's claim for an arrow declaration against AbbVie Bermuda. In case I'm wrong about that, I shall go on to consider whether FKB should have permission to serve its claim on AbbVie Bermuda outside the jurisdiction. So what follows in paragraphs 81 to 123 are expressly obiter dicta. For the purposes of a different point, I need to draw your attention to something I'll be coming back to, which is that in paragraph 83, Mr. Justice Arnold made reference to comments by Lord Sumption in Abella and Bardarani about whether it was any longer appropriate to describe service outside the jurisdiction as exorbitant. And I'll be coming back to that, but I just note for present purposes that that was part of the analysis. But the critical point for present purposes is that in paragraphs 106 and 107, well, let us start actually at 100. The court considered, and I think you were showing some of this yesterday, position under the tort gateway. And the critical reasoning is at 106 and 107. First of all, the judge says in the sixth line that it makes sense to construe Gateway 9 consistently with the requirements of Brussels. Then in the last four lines, he says, above all, I find the reasoning of the Court of Justice in Foley and Fisher persuasive, and I consider it equally applicable to Gateway 9. Accordingly, I conclude that a claim for a negative declaration that no tort has been or will be committed falls within Gateway 9. Now, that is, to an extent, in itself a stretch on the basis of the words of Gateway 9, because Gateway 9 says a claim is made in tort. But I don't need, for present purposes, to challenge that, because Mr. Justice Arnold made abundantly clear in these obiter dicta that the reason that an arrow declaration was regarded as falling within those words was that set out in paragraph 107, i.e., penultimate sentence. In substance, it is a declaration that FKV will not commit any tort so far as patents in Family 5 are concerned, because it will have a direct defence to any claim for infringement. It was, in other words, the mirror image of an infringement claim, or to use the expression in Foley and Fisher, there was simply a reversal of roles. But for all of the reasons that Mr. Pickford has already addressed you on, a claim for a declaration about whether the PPL or parts thereof is frowned simply doesn't come within those words or that concept. The declaratory relief which Mr. Chatsfield wishes to seek is not on any view for a negative declaration that no tort has been or will be committed. Establishing what FRAND licensing terms may be does not establish that no tort has been or will be committed. Now, my Lord Justice Nugee was quite understandably testing this morning various hypothetical scenarios and asking whether or not they were analogous to a declaration of non-liability. But I say respectfully that that exercise, in a sense, has demonstrated the danger that my Lord also referred to this morning or earlier today, which was that of taking judicial dicta and applying them as if they are in fact the rule or in substitution for the rule. Because the rule that we are applying here is Gateway 9, and we know what that says. It says a claim is made in tort. Now, in these overture remarks in Fujifilm, by a process in effect of analogy, Mr. Justice Arnold has decided that those words can include a claim for a declaration of non-infringement. But that is in itself an extension or an analogy which doesn't fit especially well with the express words of the Gateway, but it was done in order to make the law consistent with Foley and Fisher under the Gateway. Allowing then, if one then takes by analogy with the analogy, and then allows further categories of cases to come in, whereby one says, well, no, these are not actually concerned with non-liability at all, but they're concerned with particular aspects of the relief that somebody might conceivably be able to see, then one has, by that process of accretion and of taking the words in Fujifilm as if they were themselves the rule, one has ended up expanding very significantly the scope of Gateway 9, and one has simply left behind the words of the rule. And it became, the reason I referred to the reference to Abella is that for a while it became customary in these sorts of cases to refer to those remarks in Abella as justifying a wider approach to the interpretation of the Gateway. But that was something that Lord Sumption specifically rejected in Brown. And we have that in Authorities Volume 2, Tab 20. And at page 209 of the report, paragraph 31, in just between letters F and G, Lord Sumption says, indeed, Professor Briggs has gone further, proposing that in light of my own comments in Abella, the time has come to downgrade and eventually abolish the jurisdictional gateways and make forum conveniens the sole criteria for service out. In my opinion, this approach is contrary to principle and is not warranted by anything that was said in Abella. The jurisdictional gateways and the discretion as to forum conveniens serve completely different purposes. The gateways identified relevant connections with England, which define the maximum extent of the jurisdiction which the English court is permitted to exercise. Their ambit is a question of law. The discretion as to forum conveniens authorises the court to decline a jurisdiction which it possesses as a matter of law because the dispute, although sufficiently connected with England to permit the exercise of jurisdiction, could more appropriately be resolved elsewhere. The main determining factor in the exercise of the discretion on forum conveniens is not the relationship between the cause of action in England, but the practicalities of litigation. The purpose of the discretion is to limit the exercise of the court's jurisdiction, not to enlarge it, and certainly not to displace the criteria in the gateways. And then just skipping a sentence, in Abella against Badarani, I protested against the importation of an artificial presumption against service out being inherently exorbitant into what ought to be a neutral question of construction or discretion. I had not proposed to substitute an alternative and equally objectionable presumption in favour of the widest possible interpretation of the gateway simply because jurisdiction thus conferred by law could be declined as a matter of discretion. Now that passage was cited by the judge below, paragraph 86 of his judgment. He dealt in paragraph 87 with the point that only Lord Hughes agreed with that passage, and he points out paragraph 87, the learned judge, Core, tab 9, page 125. Sixth line. I do not detect from the judgments of Baroness Hale or Lord Wilson any disagreement with the passage from paragraph 31 of Lord Sumption's judgment, which I've just quoted, and then he cites the passages of Baroness Hale which support that approach that my learned friend doesn't challenge that. It's not in the bundles, but I can read it into the transcript. Lord Sumption's reasoning has since been cited by this court in a case called Orexim Trading Limited, 2018 1 Weekly Law Reports 4847 at paragraph 34 in the judgment of Lord Justice Lewis and the Court of Appeal. So we say it wouldn't be right to take an expansive approach to the gateway, the words of which are intended to define the maximum extent of English jurisdiction. Fujifilm, for reasons of consistency with the European jurisprudence, indicates that the gateway ought to extend to claims for negative declarations that no tort has been committed, which are in effect the mirror image of infringement claims. The present claim is plainly not such a claim, and there is no warrant for extending the meaning of the gateway to embrace the claim that my learned friend wants to bring. My learned friend also mentioned Pfizer in his note, but that was, as Mr. Pickford has already observed, not a case in which there was any challenge to international jurisdiction at all. I'll come back to it in the context of the second stage of the analysis about reasonable prospect of success. And there is then the question of what on earth the case on damage in the jurisdiction is, which Mr. Pickford has already addressed you on. I had no idea what he said because the case was only explained orally yesterday. I don't know what the damage said to be sustained in the jurisdiction actually is. There was lots of reference to business uncertainty, but as Mr. Pickford pointed out, that was actually a point that His Honour Judge Hacon dealt with and rejected. But at any rate, one doesn't need to get there because it simply doesn't fit within the gateway before one has even got to damage. So that's gateway 9. I then turn to gateway 11, which is the UK property gateway. We can pick that up again in Authorities Volume 1, Tab 3. Second page, headed Claims about property within the jurisdiction. And the criterion is the subject matter of the claim relates wholly or principally to property within the jurisdiction. And then there's a proviso. And the judge was, in our submission, clearly right to find that that gateway was not satisfied. As of the 1st of April 2019, which was the date adopted for the evidence below, there were 6,644 patents within the HEVC advanced pool, a figure which had risen to 7,113 by July 2019, of which only 2.43% are UK patents. Now, Vestel has tried to get around that by deleting all the relief except for that in relation to its counteroffer of the 18th of January 2019 and the paragraph 93A relief for which it needs permission. And one can see that in the amended particulars of claim, core tab 15, page 169. You were shown it yesterday. The two declarations that survive, I say survive to be sought, in the case of 93A, are the 93.5 declaration, the terms of the claimant's counteroffer of the 18th of January 2019 are FRAND, and then you have the 93A relief, which you've already looked at. But in fact, both of those forms of relief continue to relate to the whole global pool. The first of those is 93.5, the terms of the claimant's counteroffer of the 18th of January 2019. That counteroffer was, as the judge recorded at paragraph 16 of his judgment, simply a markup of the global PPL. And it therefore related to the entire pool. And the declaration, therefore, at 93.5 is squarely caught by the judge's reasoning at paragraph 113 of his judgment, which you've already seen. And it's not within Gateway 11, we say, on any view.
Did it offer, we don't need to know what the rates are, which are probably confidential, but did it offer a separate rate for UK patents and other patents?
I'm really not trying to be obstructive. I don't believe I can answer that question without trespassing into something confidential, and I would have to ask you, I think, to sit in private. Perhaps I can check the answer over the short adjournment.
Why don't you check the answer and see if you're able to say anything without having to go into private, or if you want to go into private, or if you don't want to answer.
I will do.
Thank you.
One then has the 93A relief. Now that doesn't solve the problem for the reason given by the judge at the end of paragraph 115 of his judgment. We can just quickly pick that up before the short adjournment. Page 130 of the core bundle at tab 9. 6 lines down, the learned judge says, not only that, the last sentence of proposed paragraph 93A makes it clear that even if the court addressed only UK designated patents, Vestel would still seek a FRAND ruling on all the patents in the pool, since the license for the UK patents would be part of a global license. An alternative way of inviting this court to settle a global license, in reality, the claim would relate to all the SEPs in the advanced pool. After the short adjournment, I'll be taking you through some further references that make that point good, and I shall, of course, be addressing the point that my learned friend makes by way of an attempt to draw an analogy with Unwired Planet and Conversant, which were, of course, patent infringement claims based on 6 and 4 UK patents, respectively. And I'll be submitting that means that there really is no analogy to be drawn between the two situations, but I shall come to that. But that is probably subject, of course, to your lordships and your ladyship at a convenient moment.
Yes, I think so. We'll say 2 o'clock, unless either of my colleagues want to ask anything. 2 o'clock. Thank you very much. Are you reasonably on track, Mr. Segan?
Yes, I am.
I thought you probably were. Thank you.